in the matter of the November 8th election regarding the Attorney General race superintendent for public instruction. State Representative for District 13. On behalf of the petitioner, we have Mr. Gaona appearing today, Daniel Barr on behalf of Chris Mays, and Tim Lasota is here on behalf of the requested intervener, Mr. Hamadeh. And so let's take that up first, the motion to intervene, and then the motion for stay filed by Mr. Hamadeh. Anybody, I guess by anybody, I'm talking about the petitioner or Ms. Mays, have any objection to the motion to intervene?
Your Honor, on behalf of Secretary Hobbs, we do object to the motion to intervene. There is no basis for intervention in this case. The Secretary's view is that the recount statutes provide for certain ministerial duties, both for the Secretary and the court, and there is no reason under Rule 24 or otherwise to allow a party to intervene at this late stage in the game.
Well, is it your position they shouldn't be allowed to intervene at all because intervention isn't really, this case really isn't susceptible to intervention, or is it your position that they shouldn't be allowed to intervene at this late stage of the game?
I know in prior recount cases, Your Honor, that intervention has been allowed at an early point in the case. Here we are. I literally have the sealed envelope of results to present to the court, and we have a party intervening, asking for a stay. And the only other fact I would add to that, Your Honor, is that in terms of the timing of the request for a stay, as I understand the motion for intervention, it's based on a tweet from an ABC15 reporter that posted at 4:55 p.m. yesterday. And if my email is correct, I didn't receive a motion to intervene until 8:57 this morning, so 63 minutes before this hearing was supposed to start. So I don't know what there is to add in terms of intervention at this point, but the Secretary, for the record, does object.
Okay. I am going to allow Mr. Hamadeh to intervene. I think the real issue is the motion to stay. So, Mr. Lasota, my understanding is, tell me, that the Mojave case is over and there's a final order entered. Is that right?
Your Honor, there is not a final order entered in the Mojave case.
I wasn't sure about that, but there has not been.
That's correct.
But the judge has made a ruling.
Yes. I mean, for all intents and purposes, in fairness, it is that, I mean, we could do a motion for a new trial, but, I mean, this is, the lateness is because of the very recent development, which has not been confirmed yet.
I just, my inclination, I'll let you try to talk me out of it, is to deny the motion for stay because the case is over. And what you've talked about in your papers is we're going to file a special action. Well, that doesn't mean the case isn't over. I mean, so that's my inclination. You can tell me why I'm wrong.
Thank you, Your Honor. Well, I don't think the case is over. I think the statute 667 contemplates that when an election, and basically it just says it abates when an election contest is filed. It doesn't really say when it unabates. So I know you're again given a statute that's not terribly precise, but I think the bottom line is it is ongoing. So I think that this should be stayed. The other thing is I think this ministerial argument is not very availing. I mean, I think this process exists for a reason. I mean, I think in many cases it is sort of perfunctory, but I think if we have the issues that Mr. Archer, who's a very respected journalist at ABC News, indicates we have, I think that this court should not really approve anything until it gets a little better idea of what could account for such a large discrepancy in a recount.
Okay. All right. I think I know what your position is, Mr. Gunny, but you can...
Sure, Your Honor.
Go ahead.
And I assume your assumptions are correct. I have here in my hand, and I'm happy to get to the court, a copy of the minute entry that Judge Jansen issued.
Yeah.
Can I approach, Your Honor?
Please. Sure. Thanks. I'm guessing Mr. Lasota's seen it.
Yes. To add some context to this, Your Honor, the trial in the Mojave County action occurred on Friday, just this past Friday, the 23rd. At the conclusion of that trial, Judge Jansen ruled from the bench, denied the election contest, found that the contestants failed to carry their burden, and Judge Jansen, specifically asked Mr. Lasota if he'd like a written order assuming, I believe, that Mr. Lasota intended to file an appeal. Judge Jansen said he could have that order in by Monday, and Mr. Lasota, and I'm paraphrasing him incorrectly, but said something to the effect of, "We'd like an order, Your Honor, but don't worry about it. Don't rush yourself, don't make doors over the Christmas holiday, of course." So there could have been an appealable order entered as of Monday, and had that happened, we actually could have had an appeal resolved. The court is, I think, well aware of how quickly the Supreme Court tends to handle these things. So now what we're hearing at the very last minute is that the contestants plan to file a special action in the Supreme Court, which of course would be entirely discretionary. So I think I agree with the court's inclination. There is no ground to stay. I have the results right here. And in terms of the merits of what Mr. Lasota has to say in his argument, I don't want to say too much as one of the two people in the courtroom here who know what is actually in this envelope for sure and what we're going to report to the court. And Your Honor, I apologize. Actually, I forgot to introduce Corey Lorick, who's the state elections director who is here with us in the courtroom today.
Morning.
And her declaration is actually one of the documents that's in the sealed envelope.
Okay.
So I don't want to say much more about the merits or lack thereof until the court's made a decision and how that affects what you may or may not do.
All right. Very good. Mr. Lasota, I'll give you the last word if you...
Thank you, Your Honor. There is no actual specific statutory right to an appeal in an election contest. Technically, you don't need one of those signed 54B or C orders. I think that the judge had worked very hard to get us where we were. I think that there was a fairly clear record. I just said I don't think you have to work over Christmas, and that was...
I'm not going to hold that against you.
Oh, thank you, Your Honor. This is the very last minute. I told Mr. Gaona in the hallway that I probably wouldn't be here, but for the reports that, a 511 vote deficit has decreased apparently significantly. I guess we're going to find out soon. Mr. Gaona knows. But yes, these things are very last minute. So I think that those sort of arguments are not terribly persuasive, and I think that we need some further inquiry into what is happening in terms of the recount.
Okay.
So,
Mr. Barton, I'm sorry. Did you want to say something?
Yes, just briefly, Your Honor. Dan Barr for Chris Mays. What we have here is a request to enter a stay on an order that doesn't exist yet, that he can't appeal from. And he says it's not because of the merits of any appeal that I plan on filing, but because of a tweet last night by a journalist who was passing on a rumor that he said he didn't know was true or not. That's why we're here.
Yeah. All right. Well, I am going to deny the motion to stay. I think the reasonable answer of the question that Mr. Lasota poses, when does it unabate, is when the case is over. These cases are unusual. We don't have them all the time. The case is over, and the fact that there is a discretionary special action plan to me doesn't mean that the case isn't over. That really, for all intents and purposes, has been a final order entered. So for stay is denied. So, all right, we'll move on to the recount portion of this. We had some discussion already about what the court's role in this, ministerial, perfunctory, whatever you want to call it. Looking though at the statute, it appears to me of 16665 that the court announces the result and makes and enters an order setting forth a determination. It sounds like that's what my role is. Is that?
Yes, Your Honor, we would agree with that. What's in this sealed envelope here, just so the court is aware, is a formal report from the Secretary of State's office that goes through the results of the recount. That report is supported by a declaration from Ms. Lorick, attached to which is a summary report of the results statewide, and then for each county, a listing of the summary results. So there's an exhibit that's attached to that. We've also included a proposed order in that for the court's convenience. Okay. So I don't know if the court wants to, I'm happy to bring this up, to have the court open it and take a few minutes to make sure that everything's here. And obviously we have Ms. Lorick here in the courtroom to the extent the court has any questions.
I was going to ask you procedurally how you wanted to proceed, but that's what seems to make sense to me. Just bring it to me. I'll look at it, and then we can talk about how you want the results announced. I assume you want the accompanying declaration and then the results filed in in the record.
That's correct. That what is in the envelope are 2 copies of both the report and the declaration, which we did not file through Turbo Court before coming here today because we were awaiting the court's order. So we whether the clerk can file it directly here or you'd prefer us to file them by Turbo Court after the court has entered its order, we're happy with whatever the court wants to do there.
We'll talk about that before we finish. So if you want to bring that up, that's great. Thank you, sir. I can't help but think of those of us that are old enough to remember Johnny Carson's medically sealed Pumpkin Waggles Porsche.
I'm sure that might be a funny hat for you someplace.
Yeah,
I think Mr. Lasoda said it looks something like the Oscars. So
I think didn't Carson go?
right.
Declaration and the order. Okay. 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 And Mr. Gannett, which I think I would envision just reading where there, I don't know if that I need to read the entire report. I think maybe starting in paragraph 2, reporting what the Secretary certified in paragraph 2.
Yes, Your Honor. I think that's right. And then ultimately, we do need the signed order,
Yes.
certified copy of which needs to get to the Secretary.
Yeah, we'll take care of that. I'll make sure we take care of that. So the court has been provided the Secretary of State's report of the recount results and the accompanying declaration of Corey Lorick. Both of those documents will be filed in the record. And the Secretary of State's report, the court will announce the result under ARS 16665. The recount results for the Office of the Attorney General is as follows. Chris Mays, 1,254,809. Abraham Hamadeh, 1,254,529. I'll repeat that. Chris Mays, 1,254,809. Abe Hamadeh, 1,254,529. The court announces the Secretary's certification of the recount for the Office of the Superintendent of Public Instruction as follows. Tom Horn, 1,256,406. Kathy Hoffman, 1,247,218. I'll repeat that. Tom Horn, 1,256,406. Kathy Hoffman, 1,247,218. And the court announces that the Secretary has certified the recount for the results for the Office of the State Representative of Legislative District 13 as follows. Jennifer Pollock, 47,164. Liz Harris, 43,830. Julie Willoughby, 43,555. One more time on Legislative District 13. Jennifer Pollock, 47,164. Liz Harris, 43,830. Julie Willoughby, 43,555. So the order me just take a quick look at it. I'm sure it's fine, but. I'll read it and sign it, and then we can talk about procedurally how you probably want to handle it. So the court will enter the order, which will read as follows: a recount of the votes cast in the November 8th, 2022 general election for the offices of Attorney General, Superintendent of Public Instruction, and State Representative for Legislative District 13 having been conducted according to law, and the results having been reported as follows. Again, Chris Mays, 1,254,809. Abe Hamadeh, 1,254,529. Superintendent, Tom Horn, 1,256,406. Kathy Hoffman, 1,247,218. State Representative, District 13, Jennifer Pollack, 47,164. Liz Harris, 43,830. Julie Willoughby, 43,555. It is hereby ordered that candidate Chris Mays receive the highest number of votes for the office of Attorney General. Candidate Tom Horn received the highest number of votes for the office of Superintendent of Public Instruction, and candidates Jennifer Pollack and Liz Harris received the highest number of votes for the office of State Representative Legislative District 13. It is further ordered pursuant to ARS Section 16665B2 that a certified copy of this order will be delivered to the Clerk of Court to the Secretary of State, and it is further ordered that the Secretary of State shall deliver the prevailing candidates an official certificate of election forthwith in accordance with ARS Section 16665B2, and it will be signed as of December 29th, 2022. All right, so procedurally then, Mr. Guyona, how do you want to proceed as far as the deliverance? I don't know how that should work.
We're happy to, if the court staff can help us get the certified copy, we can.
Oh, sure.
It can be delivered directly here to Ms. Link on behalf of the Secretary.
Okay.
And that we can solve that component of the court's order.
Okay.
Right here in the courtroom. And then if the court is also able to file, the clerk's office rather, to file those documents that you have, we can do it that way, or I can have my assistant file them via Turbo Court as soon as we're
We'll go ahead and file those in here. We'll have our clerk file them in. Okay, then let's get the certified. How many certified copies do you need?
Just one is fine, Your Honor.
Okay. Because the official certification, the last thing, that's something different, right?
Yeah.
So then you guys take care of that.
Correct.
Okay. Mr. Soda.
Your Honor, I would ask that you delay entry until the close of business just to allow us to review potential legal options for.
Okay. I understand, but the request is denied. So, all right, we'll get your certified copies and a certified copy, and then you can then have that delivered right here in court, and we should be done.
I think that's right, Your Honor.
Okay, very good. All right.
Thank you, Your Honor. We appreciate it.
Thank you. Okay, so.